Audio check. Teams audio check. Right, good morning everybody. 9:30 and we can resume the inquiry. This morning we're hearing from Mr. Hunter-Jones for BAL, and then we're switching to hearing from Mr. Johnson for PCAA, and then hopefully we can then begin Mr. Urson Ireland for the appellants, and we'll see how far we get with that. We've got no housekeeping matters. Anybody got anything that we need to pick up on? No? Okay. Over to you then.
So thank you very much indeed. Good morning. Just by way of preamble, I've estimated an hour and a half. I might go to an hour 45.
I can live with it.
Thank you very much, sir. Thank you. Mr. Hunter-Jones, good morning. May I introduce you to the inquiry? You are Sam Hunter-Jones. You are a solicitor of the Senior Courts of England and Wales, practicing as an in-house lawyer at Client Earth, a not-for-profit charitable organisation of environmental lawyers that work to protect the environment with the job title of senior lawyer. Since joining Client Earth in 2017, your work has focused on the law and policy relating to climate change, including in the area of planning policy and decision-making. And this has involved scrutinising the consistency of a number of proposed projects and policies with the UK's climate change objectives and relevant legal obligations in the context of both local and nationally significant infrastructure planning. You've also made submissions on these in consultations and examinations where Client Earth has been a party, and before that you worked at the international law firm Freshfields, and you have an LLM in environmental law and policy from University College London. Mr. Hunter-Jones, you've provided a proof of evidence and a supplementary proof of evidence to the inquiry. Is that all still the case as far as you're aware?
Yes, that's right.
And then there's just one error in your proof that we picked up. That's at paragraph 4.2 on page 12. That refers to CD 6.4. That is correct. But the title there that's given is the title for CD 6.3. The title that should be there, obviously, is making best use of existing runways, that part of the beyond the horizon, rather than the next steps.
That's correct, yeah.
Thank you very much. So, as previously with the witnesses, we're going to take all your evidence as read, and I'm just going to pick up particular parts with you. So can we look, please, first in your section 2. There you give your introduction. I'm not going to pick up anything in there. Turn over to your section 3 on page 6, and you start with the UK's climate obligations under the Climate Change Act and current progress. You set out an overview of the Climate Change Act and the net zero obligation, and you refer to the then-draft, now made carbon budget order, adopting the 6th carbon budget. And in your paragraph 3.7, you refer to the explanatory memorandum to that, confirming the government will make regulations to include international aviation emissions in that budget. You then, in the next paragraph, refer to what the appellant has said about the Kyoto Protocol in its statement of case. And can I ask you, please, to look at the Kyoto Protocol, which is CD 9.20.
Yes, I have it.
And within that, can you go to page, well, we'll start on page 2, where we've got Article 2 of the Kyoto Protocol. That puts an obligation on Annex 1 parties in order to achieve quantified emissions limitations. And there are a number of bullets under that. And then Article 2.2 says that the parties there listed shall pursue limitation or reduction of emissions of greenhouse gases not controlled by the Montreal Protocol from aviation and marine bunker fuels, working through the International Civil Aviation Organization and the IMO, respectively. So first, what does that mean in terms of working through the ICAO or ICAO?
Well, as I understand it, this article of the Kyoto Protocol establishes the parties' agreement to work through ICAO and the IMO in terms of shipping, but for aviation through ICAO to pursue limitation of greenhouse gases at the international level. And that's that since then, the parties to the agreement have been working on that, and I've discussed the kinds of mechanisms and measures that have been put in place by ICAO later in my proof.
And just looking at those two parts of Article 2.2, we've got the requirement on the parties to pursue limitation or reduction of emissions from the various sources. When it says that part working through International Civil Aviation Organization, to what extent does Article 2 require governments only to work through ICAO?
So my understanding of the article is there's no restriction whatsoever on further measures being taken at the domestic level by states. It merely talks about the framework to be established at the international level.
And when it comes to addressing international aviation emissions, does ICAO have some kind of exclusive competence, or does it not? What's the position with ICAO?
I'm not aware of any formal exclusive competence in respect of ICAO. It's the mechanism that the parties have agreed to work through in limiting aviation emissions at the international level.
And to what extent does Article 2 prevent emissions from international aviation being a material planning consideration in decision-making?
I can't see any reason why Article 2.2 would have that effect in terms of the planning framework at issue in this appeal.
And of course, the appellant and other parties address international aviation emissions, and I'll talk about that a bit later. Further on then in your proof of evidence, please, the next pages 8 and 9, you set out there the position under the Climate Change Act, the UK's carbon budgets, and you provide us with two figures, table 2.1 and figure 10.2, and then over the page 10 and 11, you also set out the position as updated, and you provide us with figure 1.1. You will have seen that figure 1.1 and table 2.1 were the matters of discussion yesterday. What is your understanding of whether the UK is on track to meet its carbon budgets?
So on the basis of current policy, it's clear from Bayes' figures and from the Climate Change Committee's analysis that the UK is substantially off track to meet the fifth and fourth carbon budgets. And the point I make in my proof is that with the introduction of the sixth carbon budget and looking ahead to net zero, there's a need to outperform the fifth budget in particular. So I think that's important context to bear in mind when you look at these figures. They are very much, at the moment, a best case scenario. Yes, that's what I'd comment on those.
Thank you. Thank you. And you'll have heard that there was discussion yesterday about the extent to which the Bayes table leaves out or excludes certain policies. What's your comment on that?
Well, as I understand it, I think the discussion was around policies that were introduced in the Clean Growth Strategy. And the footnote suggested that because certain policies hadn't yet been sufficiently certain or developed, they weren't included in the table. And I think that just reflects the length of time that it takes to develop policies and for that policy to then have an impact on emissions. And that is, I suppose, relevant context for understanding why the CCC's advice is for the UK to correct course so urgently, because it's not the case that you can simply introduce a policy and within, not only overnight, but within a year or two. If you look at the Clean Growth Strategy for 2017, these projections were done in 2020 in October. So there's a number of years for which policy needs to filter through into actual projections, let alone actual emissions reductions. So I think that's the point I'd make on that.
Then in your supplementary proof of evidence, at page 12, paragraph 4.2, you update us on the CCC's Progress Report to Parliament 2021, which has been provided to the inquiry as a core document. Just in a nutshell, what does that say about the UK's position in relation to its carbon budgets?
Well, it confirms the position we just discussed, the substantial policy gap, and it quantifies the number of what it says credible policies. This is the CCC's analysis for delivery to meet the 6th carbon budget period. It says that only 20% of the required policies are sufficiently developed at the moment. And so that's sort of a sort of more specific and detailed analysis of the situation. Obviously, there are policies that are in development and that may well help to meet the 6th carbon budget, but as things stand, there is a long way to go. As I discussed in my proof, this is all, I think, very important context when you're considering the significance of the adverse effect of climate impacts for this proposal and of greenhouse gas emissions. As well, on the specific issue of aviation demand and capacity, the CCC reiterates its advice there should be no net expansion in UK capacity.
Thank you. So just two things. In terms of, so if I'm pausing, it's just because I'm typing and catching up. That's absolutely fine. And then your voice dropped slightly at the end there, so I missed the last bit that you said.
Sorry, I was just explaining that in addition to looking at the wider UK economy picture and the policy gap, the CCC in their progress report of June this year also reiterated their recommendation around managing aviation capacity and had a more detailed discussion around the issues that could be considered by government and made a recommendation for government to do so.
Thank you. Are you aware of anywhere that the CCC or the CCC says that the UK is meeting its 5th carbon budget?
No.
Can you go back in your main proof of evidence, please, to page 6? You tell us at your paragraph 3.4 about the CCC and what it is and what its role is, and you refer us there to it being the leading specialist body, and you say that the importance of the CCC's advice in the context of planning is confirmed by national planning practice guidance, which expressly refers practitioners to the CCC's advice, and you indeed make the same sort of point later on in paragraph 4.17. Could we go, please, to CD 5.9? And you'll have seen, in fact, the inquiry website has been updated with the planning practice guidance relating to climate change. So that should be available easily for everybody.
Can I just check, does that replace the existing? I saw that.
I don't know.
Does it replace or is it like a CD 5.9.1?
Yeah, I don't know. So I have to say, usually when there's CDs that are planning practice, because there's so many different parts of the planning practice, it tends to just be either a giant melange document or a 1.1, 1.2. I'm agnostic as to which approach is taken.
For present purposes, I won't delete the original one. I've got the one that was very kindly sent this morning, and I'll just open that to follow the discussion, and we can discuss later kind of numbering if that's...
Yeah, sure. Thank you.
Okay, so can you then go in the planning practice guidance, please, to page 5, under the heading, where can I find out more about climate change mitigation and adaptation? And can you tell us what you want to about that, please?
Yeah, so I'd simply point to the reference to the Committee for Climate Change, it says here, but it's now known as the Climate Change Committee, is that the fact that it's an independent statutory body established under the Climate Change Act 2008, to advise the UK government on emissions targets and reports to Parliament on progress made in reducing greenhouse gas emissions. And I think there are a number of places in policy and in practice where the CCC's analysis has been confirmed as clearly relevant to planning, but I think this is another example of that.
So in relation to the appellant's case, that the CCC's advice is just advice and not government policy, what's your response?
Well, I suppose that's correct in as far as it goes, but I think where I disagree, as I understand the appellant's position, is that that argument is used to suggest that the CCC's advice is not relevant to assessing the significance of a climate change impact.
I would make absolutely clear we have never suggested that the CCC's advice is not a material consideration, not relevant. All I have ever sought to distinguish is between what is policy, because that has a status in planning, and what is advice. Never ever said it's not relevant.
I apologise if I misunderstood the appellant's position. From the discussions I've seen, there's been a lot of attempt to close down debate around climate impact on the basis that it's not government policy. In terms of the planning framework, I don't see where that takes us. It's clearly, if the appellant accepts it's a material consideration, that's fine. But I think I understood the argument to be that as there is not government policy sort of formalising the CCC's specific advice, then that makes it somehow of less worth or weight. And I don't share that view.
Yeah, if it helps, the way that I've understood the discussion is effectively what you just said, that there is a distinction between policy, which has a particular status, and other material considerations, such as CCC, and one can then debate the weight that one gives them. But yeah, I certainly didn't take from any party the suggestion that CCC is not relevant. It's just a matter of weight.
And to what extent, when one is considering the weight to give to the CCC's advice, does one take into account the planning practice guidance that we're looking at?
Sorry, could you repeat the question? Sorry.
Yes. To what extent, when one is considering the weight to be given to the CCC's advice, does one take into account the planning practice guidance that we're looking at?
Well, I think it's clearly relevant.
And you said in your answer to Mr. Humphreys and indeed to the inspector that the CCC's advice is not somehow of less weight, and you don't share the view that it's somehow of less weight. Can you expand on what your view is as to the weight to be given to the CCC's advice, in particular in the sixth carbon budget?
Yes, if it's helpful, I think the CCC's advice on this particular issue, as things stand, constitutes the best available evidence for assessing the emissions impact of this proposal at the national level. I'm not aware of any assessment of airport capacity for the purpose of planning having been done by government. And I think that all of the recent government publications confirm that making best use remains the current planning policy for aviation. And as part of that, the inspectors will be aware, my view is that making best use requires the decision maker to take account of material considerations in respect of climate impacts, and I think the CCC's advice here, in any event, would be relevant, but here particularly so.
Thank you. Can you please take up Mr. Melling's rebuttal, which is BAL/7/3. And in that, can you go, please, to page 10? I was just looking at the previous pages in terms of the context for where this is said and the implications for the discussion just had, but I won't worry about that. Paragraph 2.2.15, please, 2.2.15 on page 10. Mr. Melling says, the government has also not indicated that it has adopted all of the recommendations in the CCC's Sixth Carbon Budget Report, nor has it indicated that it will adopt a demand management policy to meet the budget for international aviation. Government policy therefore remains that forecast passenger demand should be met subject to environmental considerations. Your response, please.
Well, I suppose it's similarly to the point I made a short while ago. I think that the fact that the government has not introduced a demand management policy as yet does not affect the assessment of the climate impact of the proposed development. It could assist the airport in making its case if it were to resolve the issues that the CCC have clearly pointed out, if we are to take a credible and feasible approach to meeting the net zero target. But the lack of a demand management policy does not, I can't see how that assists in minimizing in any way the climate impact of the proposed development, having regard to key evidence such as the CCC's advice, the cumulative picture, so other developments that are planned or have already been consented.
And similarly, the appellant points to the fact that there's not just no policy, well, maybe it is the same point, preventing the expansion of airports. So not just that there's no policy in relation to demand management in general, but there's no policy preventing the expansion of airports. I mean, maybe your answer is the same, but in case you want to say something else, I'll just give you that opportunity.
Yes, I think rightly or wrongly, the government hasn't yet introduced an airport capacity constraint policy or demand management policy as yet. Obviously, there is an element of demand management consulted on in the Jet Zero consultation, but that's at the moment just consultation. And so in that context, I don't think that there is any, I mean, that is what it is, and in that context, the inspectors have have recourse to the best available evidence to assess the project's climate impacts. Whether or not that's covered by specific national policy it may be relevant, but it's certainly not determinative of the question of a proposal's climate impact.
Can we look, please, next then at making best use, which is CD 6.4, and can you also have your proof of evidence, please, open at your paragraphs 4.2 to 4.4, that's pages 12 and 13. And
yes,
you'll see there that you set out in your 4.2 the final paragraph of making best use, paragraph 1.29, and then you work through the other paragraphs, earlier paragraphs of the policy in the rest of that, those paragraphs that I referred to. And if you turn up MBU, you'll see that on page 4, there's a heading, which is the role of local planning, and there's 2 paragraphs under that heading. Then on the next page, there's the heading, role of national policy, and 3 paragraphs under that. And then if you go later on in the document on page 8, there's a heading policy statement and a number of paragraphs under that. What is your comment on how that all interacts?
Well, I think in terms of the structure of the document, I think the most important policy for the purposes of this appeal is that included under the heading policy statement. And I think the previous discussion of national and local policy is what is it's used as context, and it informs the statement, I think, at the outset of the policy statement section, where it says, as a result of the consultation and further analysis to ensure future carbon emissions can be managed, the government believes there is a case for airports making best use of their existing runways across the whole of the UK. So, as I see it, the preceding analysis is an explanation of the approach the government has taken as to whether or not the policy approach they then go on to describe is reasonable and can be delegated in effect to local planning authorities to consider all the issues in the round. And also paragraph 125, that statement, there is a case, the government believes there is a case for airports making best use, is clearly tentative and is based on the specific analysis, expressly so, that precedes it. So I don't, I think it may have been suggested by the airport that the preceding discussion of the national carbon targets and effect of making best use on those is somehow incorporated into policy. But as far as I can see, that is simply an assessment that's informed the approach taken in policy. And it's informed the approach to which the government has said that it's for local decision makers and under local planning frameworks, applying those particular policies to take the judgment as to whether in each case the merits of the proposal outweigh the disbenefits.
Turning then under the policy statement section to the next paragraph, we've got paragraph 1.26. And at the end of that, that paragraph picks up that as part of any planning application, airports will need to demonstrate how they will mitigate against local environmental issues, taking account of relevant national policies, including any new environmental policies emerging from the aviation strategy. And then later on, we get paragraph 1.29, which is the one in bold at the end. And that states that the government is supportive of airports beyond Heathrow making best use of their existing runways, but says this: however, we recognise that the development of airports can have negative as well as positive local impacts, including on noise levels. We therefore consider that any proposals should be judged by the relevant planning authority, taking careful account of all relevant considerations, particularly economic and environmental impacts and proposed mitigations. This policy statement does not prejudge the decision of those authorities who will be required to give proper consideration to such applications. It instead leaves it up to local rather than national government to consider the case on each case on its merits. What do you take from this emboldened paragraph 1.29?
Well, I think, as you say, it is in bold. I think it's the key policy that can be derived from the document. It is very pointed in referring to the need for the relevant planning decision maker to take account of all relevant considerations, careful account indeed, including environmental impacts and proposed mitigations. It doesn't prejudge the decisions of local authorities, and it gives them the say effectively on each case. I think I might add as well that I've referred in my supplementary proof to the fact that I think this is supported by the DFT response to North Somerset Council, where the DFT have referred to making best use and the assessment of emissions in response to a question about the methodology to be used. when assessing climate impacts. They then go on to say that notwithstanding the fact that it's current policy and part of the airport planning framework, the aviation planning framework, nonetheless it may be given less weight. So I feel like that is a useful framing within which to view MBU. It gives guidance as to the kind of approach that you might take sensibly to looking at a national issue like carbon emissions in a cumulative way. But it certainly doesn't settle as policy that issue and that assessment. I mean, I think it's well established as a matter of planning law that a policy cannot make or exclude from being a material consideration something that would otherwise have been a material consideration. And I think, again, as I understand the appellant's case, often they're relying on MBU as a way of closing down the consideration of cumulative climate impacts at the national level. And that doesn't make sense when you read the policy. Sorry?
That's absolutely wrong. We haven't used MBU for that purpose. We've used MBU in forecasting as relating to meeting demand. In climate change, all we've said is MBU tells you the difference between what's national and local.
In that case, then that's fine. I accept that.
I think we're agreed on.
Yeah, then we are agreed. But I have detected in questions and discussion an attempt to say that I think I have to try and remember the exact paragraph number from Mr. Erzen Island's proof, but he suggests that MBU means that carbon emissions are a matter simply for national measures, and they're not a consideration under local planning policy.
Yes, can you go then to that? I was going to ask you about that later, but let's go there. That's Mr. Ozen Island's proof of evidence, paragraph 3.5 on page 10. It might be his rebuttal. We had a delightful canter through my ability to misunderstand where things were in Mr. Ozen Island's evidence yesterday, but I think it's in his main proof. I'll start off there anyway.
That was my recollection, but I might be wrong. I think it's paragraph 3.5.10.
Right? On page 35, there we go.
Yeah.
Thank you.
It says, in summary, there are national and local planning policies that are relevant to the appeal proposal. It is clear, however, from paragraphs 1.8 to 112 of Beyond the Horizon, Making Best Use, that development control policies are not intended to apply to carbon emissions from domestic or international aviation. Those are a matter for control at a national and indeed international level. Now, I don't know if Mr. Humphreys wants to add a gloss to that, but I think it's clear that it's been relied on there as a way of saying that MBU is saying that national measures and national decision makers are the only competent, if you like, decision makers that can consider carbon emissions from individual planning proposals. And I think if that was the case...
Can you let the witness answer,
Yeah.
please?
Well, hold on a second.
I'm very keen not to interrupt, but I also don't want Mr. Hunter-Jones's evidence to sort of go off on a, like ships in the night. We pass. He thinks we've made one case, and we've made another.
Well, what I prefer is that he gives his full answer.
Yeah, let's
So
get
that I'm
the
clear on what he
answer out
says.
first.
Okay.
So
Thank you.
I was just going to make the point that if the policy had intended to do that, it would have said so in terms. And it clearly doesn't do that. It doesn't say that. And I think, as I said, as a matter of context and interpretation, that doesn't work as a matter of planning law either.
Okay, and then if anything needs to be said as to that not being the correct understanding of the applicant's case, without interrupting the witness, then please do. So turning back then to MBU, and that final paragraph 1.29, What do you take from the language in that last sentence, like second last sentence, that the policy statement does not prejudge the decision of those authorities?
I think it simply means that it reinforces the point, emphasises the point that the decisions will need to be made on a case-by-case basis by the relevant planning decision maker, and obviously it probably is also cognizant of the fact that circumstances will change over the life of the policy, and that's why it can't prejudge the issues. I might also add, if it's helpful, context, that I think what the government has done with MBU is that it seems to have, rightly or wrongly again, taken a bottom-up approach to deciding which airports should go forward, which expansions should go forward and which should not. The CCC's advice seems to be more of a top-down one. That seems to be the difference. But what I would say is that clearly the government is expecting the relevant decision maker to take account of all effects, all material considerations, and all circumstances. And that is consistent with general planning law principles and perhaps what you'd expect for a policy of this nature. It's also, for what it's worth, consistent with the approach taken in the ANPS, which the Supreme Court has confirmed, but the policy is clear, means that the decision maker needs to assess the impact on climate change at the time the application is brought forward. So if that, in case that's helpful context.
Okay, we'll look at the ANPS in a sec. I just want to ask you two more questions about this. So, back to your proof of evidence, please, pages 12 and 13. You address there the Stansted decision, and you make some points about the approach that is taken in that decision, and whether it appreciated the nature of the policy correctly. Now, the appellant relies on the Stansted decision. What would you like to say about that?
Yeah, so in my proof, I've explained where I think the panel in that application has gone wrong in terms of interpreting the policy and understanding the wider context. Yes, hopefully that's useful for the panel to consider.
And just in light of the clarification that we've had from the appellant, that their case is not that MBU takes the climate change matters off the table or makes that a matter just of national rather than local decision making. What's your comment on that as in light of the Stansted decision? How does that fit or not fit with the Stansted decision?
Yeah, I was not involved in the Stansted appeal inquiry, but from the decision and the way that is worded, it would seem that the inspectors have assumed that the reference to MBU as current government policy, in effect, resolves the issue of the project's climate and carbon emissions. And I think that maybe perhaps where the confusion is, if the appellant is relying on the Stansted case, then perhaps partly where my confusion, along with the position taken by Mr. Ireland, perhaps that's where it's arisen.
Sorry, I just missed that last bit of your sentence.
Perhaps that's where that misunderstanding or confusion has arisen, given that the appellant is relying on Stansted. But as I say, I think Mr. Ireland's proof quite clearly makes that point as well.
And then finally on MBU, can you just explain, please, what the difference is between Ban's case on MBU and the North Somerset Council's case on MBU?
Again, I don't want to categorically speak for the council. I think I heard Dr. Hinnell's giving evidence and referring to the fact that it would not be safe to approve the current proposal in light of the CCC's advice and the fact that, that there hasn't been any government policy resolving this capacity risk in terms of climate change, and I'd agree with that. So yeah, that's what I say.
And in terms of the council's reliance on prematurity, where does that stand in relation to the case being put by Ban?
Well, again, I think for the council, again, to clarify and to explain, but I think prematurity here is made. The point is perhaps made in that context of it's a more it's a generous way of saying perhaps that the proposal's climate impacts are unacceptable, because it's saying the government could bring in a policy that that resolves the inconsistency with the balanced pathway and the CCC's specific advice. It hasn't done so, and in that context, it's premature. But I think, as I've explained in my proof, that doesn't prevent the inspectors from taking a judgment on the best available evidence as to what the proposal's climate impacts are.
And so, to what extent does Ban criticise or seek to ask the inspectors to step away from current planning policy, or put forward what planning policy should be?
Well, from Ban's opening statement and everything I've heard, certainly in my proof, I've taken the position on the basis of current policy and the currently applicable material considerations that I see applying. In the context of climate change, obviously, I've not focused on the appeal in the round.
Can you look, please, in Mr. Melling's rebuttal? At paragraph 2.2.18 on page 10. And you'll see there that he says...
Sorry, I've missed the reference, 2.2.18.
Oh, sorry, so, yes, this is BAL 7/3, page 10, paragraph 2.2.16, sorry, 2.2.16.
Yeah, I'm with you.
So you'll see there that Mr. Melling says that the UK government's climate change obligations do not fundamentally prevent the growth of Bristol Airport to 12 mppa. He says emissions arising from aviation is a matter for national policy, which is moving towards carbon emissions from aviation being controlled as part of the UK's carbon account on a carbon traded basis rather than the implementation of demand management. And he says it's surely axiomatic that it's not appropriate or even permissible to use a local planning inquiry as a vehicle to challenge the merits of, or indeed the weight to be attached to, clear and current government policy. What's your response to that in light of Ban's case?
Yes, so similarly to the point made about Mr. Ireland's proof, I disagree with that characterisation of the exercise facing, or the point to be considered by the inspectors. I don't think it's particularly relevant or helpful to talk about what national policy doesn't do in terms of demand management. The issue is what is the climate impact of this proposal and is it acceptable? I'd obviously disagree on my interpretation of making best use and of the wider planning framework at issue in this appeal, with the suggestion that that categorising the climate change impacts of this proposal as significant and unacceptable as being a challenge to the merits of government policy.
You mentioned in your evidence reference to the airport ANPS, and the letter concerning the airport's ANPS was provided to the inquiry. I'm not sure if that's been given an inquiry number yet, the ANPS letter that's been circulated. It's the decision on requests to review the ANPS, which was mentioned, I think, on Tuesday and yesterday, and was circulated this morning, or yesterday. Sorry, circulated yesterday, sorry. My ability to differentiate days has become diminished.
I've seen it, but I don't think it's an inquiry document.
Sir, are you all right for me to ask some questions on it, even though it's not an inquiry document yet?
Yes, there's no significance in the fact that it's not a document, it seems. Yeah, very happy to hear about it.
Okay, I'm grateful. Mr. Hunter-Jones, you mentioned the ANPS. Here's this letter from the 6th of September. What would you like to draw attention to in it?
Yeah, I think it's helpful in confirming some of the discussion, the points I've made earlier around the relevance of the CCC's advice. The letter refers to the CCC's aviation-specific advice as a significant change in circumstances since the designation of the ANPS.
So sorry, just take us to the bits which you're looking at. On page 1.
Page 1, the climate change section, that paragraph at the foot of the letter, page 1. It also refers to the declaration of a climate emergency by Parliament and the inclusion of international aviation within carbon budgets and the CCC's specific advice on aviation following its report on net zero. As significant changes. It then goes on to say that on the basis of those changes, it's not possible to conclude properly that the policy in the ANPS would have been materially different. What I think is the clear implication from that is that these significant changes are able to be taken into account and meaningfully under the ANPS, and that's the basis for the government taking that view. And I think, it's related to the point I've already made in my supplementary proof that in the Jet Zero consultation at footnote 39, when the government refers to the need for expansions of airports to meet their climate obligations, it's in the same breath. The MBU and ANPS are referred to in the same way. And I think it's a further context and confirms and supports the view that both these documents allow you to take into account, require you to take into account, in fact, all these significant changes in circumstance since the policies were introduced.
Thank you. So that's page 1 of the letter. Is there any other particular part of the letter further on that you want to draw specific attention to, or is that everything you want to tell us about?
I think just the simple point that it emphasises the need for proposals under the ANPS to be considered on a cumulative basis, taking into account other relevant plans in place at that time. I think that's just a helpful confirmation that clearly the assessment of climate impacts for an airport needs to take into account the wider picture in terms of capacity in the pipeline and capacity that's been consented against any environmental limits such as carbon that are evidence at the time.
So that, I take it you're referring there to, on page 4, there's a heading, cumulative impact of growth at other airports.
Sorry, yes, that's right. Yeah. At page 4. Yeah.
Yes, where it says the Secretary of State does consider the impact of other airport growth proposals to be a significant change in circumstances on the basis of which ANPS was decided. Growth of other airports was foreseen. And then there's a reference there to MBU and the proposals under MBU being taken forward under the Planning Act. And that as part of any planning applications, airports will need to demonstrate how they will mitigate local environmental issues in consultation with local communities, et cetera, et cetera. That's the bit you're referring to.
That's right, yeah.
Thank you. Just on cumulative impact assessment, can you please look at Mr. Oz and Ireland's proof of evidence? On page 70, at paragraph 6.6.27. So in this section of his proof, he's referring to the assessment that the airport's carried out. Page 70, paragraph 6.2.27. So he starts off by saying the assessment has contextualized emissions against the planning assumption. That's been discussed. I'm not going to ask you specifically about that. And he says, and has identified known emissions from other expansion projects where such forecast emissions are known. It's explained the effects, including international aviation, in the context of the Sixth Common Budget and ETS and CORSIA. And then he says these provisions will apply equally to all UK airports and to all domestic and international aviation, to, from and within the UK. This is, by its very nature, a cumulative approach in that the carbon budgets and the UK ETS permits are set at a national level. There is therefore no need for any further cumulative assessment, as the Sixth Carbon Budget is aligned with the UK's current nationally determined contribution under Paris and the Climate Change Act Net Zero. What's your response to that, please?
Well, I mean, as I read that paragraph, it seems to be talking about something quite different to what I was just describing just now. It seems to be talking about the need to take into account all forms of national policy in the area of climate change and aviation emissions, which of course is appropriate and necessary, but I don't see it as being a cumulative approach to assessing the impacts of this proposal in the light of wider circumstances. And I think in that context, you've got to, I think it touches on this issue that has already been discussed about significance and the airport's position that the proposed development's emissions increase is very small or insignificant, and I think that's where they haven't applied the proper approach to understanding significance in this context using a cumulative approach. If you were to do that, you'd say we have no space left for capacity on the best available evidence from the CCC. We have no space left for further expansion without reductions elsewhere. And it also, that point I think Professor Anderson elaborated on yesterday about scale. I think the points he made were absolutely right, but there's also a point of consistency as well. So when the appellant talks about the gross value added of the project to the local economy, it doesn't, as far as I'm aware, suggest that because that is 0.01% of GDP, it's trivial, insignificant, to be disregarded. Of course it doesn't. And you've got to look at the proposed development's emissions on in a proportionate scale to the project at issue. And if the project is increasing its emissions against the baseline, then that's by some 20% or more, that's a significant effect. Particularly when you look at the wider circumstances of UK climate targets, progress, and other airports planning to expand, and the lack of room for them.
So finally, just to clarify in relation to cumulative impact assessment, to what extent, if at all, are other decisions like the approval for Stansted and the approval for Southampton relevant?
So I think as I discussed in my proof, they add to the sense that there is no room for this particular proposal in light of those circumstances. Even if they weren't being planned on the basis of the CCC's clear advice, there would still be a clear problem for this proposal, but it only adds to the fact that there are no reductions being planned. If anything, many airports are planning to expand significantly.
Yes, I take it therefore, I mean, to what extent is that relevant to the fact that what the CCC is talking about is net expansion? I think I asked Professor Anderson yesterday about what's meant by no net expansion.
Yes, I think that's the point I touched on earlier about the fact that if the government did have a central capacity policy or mechanism, then they could decide to allow for certain airports to expand and others to contract, and that would be possible within the CCC's framework of advice.
Okay, but given, of course, that that's not the position, how does the no net expansion play itself out at this inquiry?
Yes, so there's no indication the government is planning at the moment to introduce that policy. Obviously, in the decarbonising transport plan, they said they're going to review policy every 5 years, if not sooner. So it's quite possible that that will be introduced. But at the moment, there's no clear statement to that effect. And so, as things stand, no matter how the proportion of emissions from the proposed development compares to UK economy-wide gross emissions, total emissions, clearly there is no room on the CCC's view of what a credible approach to meeting the net zero target is. There's no room for any further expansion. And I think that needs to be taken into account when you look at the adverse effect of the proposal, and obviously it needs to be proportionate to the scale of the development. So it's weighed, I don't need to tell the inspectors this, but obviously it's weighed proportionate to the benefits as well. And so I think it's important to keep the exercise proportionate to the scale of the project, not to get lost in the purported insignificance when looked at a national level.
Then you mentioned in that answer a couple of times decarbonising transport and jet zero, and you address those in your supplementary proof of evidence. So can you take that up, please? And you, first of all, in your section 2, on pages 4 and 5, address decarbonising transport, and you pick out particular paragraphs or parts of that document that you want to draw attention to. And then over the page, you refer to the fact that decarbonising transport looks forward to the Jet Zero consultation, and that it's supporting technological innovation that's currently of very low certainty or maturity, so it's recognising the potential need for additional policies, and that's what you were just touching on in your evidence there. And then you address the Jet Zero consultation, again drawing particular aspects of that document to attention. And then in your paragraphs 2.7 and 3.2, you make the point that neither of these documents is intended to alter the planning framework for consideration of airport expansion. Could you just tell us whatever you want to about that, please.
Well, on that last point, I think that's the footnote 39 point that the document clearly says that it's not purporting to deal with airport planning policy. That remains making best use for this type of proposal. And I think, as I've set out in my supplementary proof, the Jet Zero consultation, the evidence base, the commentary, and the decarbonising transport plan all points towards the fact that the technological changes needed to get round the need for capacity constraint are extremely challenging. They're described as very low solution certainty, and are frequently described as challenging and optimistic and aspirational. And I think in that context, it really underscores and is consistent with the CCC's analysis of what the approach you take if you were going to take a credible and feasible approach to meeting carbon targets. And it's in that context, I suppose, that I see the CCC's advice as relevant to planning and climate risk for this proposal in a way that the Jet Zero analysis is really, the evidence around technology is relevant, but the aspiration, I mean, it doesn't seem to be reliable in any sensible way in a planning context.
So you referred there in the Jet Zero consultation to the footnote. Can you turn up the consultation, please? That's CD 9.135. And the footnote is on page 51. That's footnote 35, which refers to MBU and the ANPS. So we've discussed both of those.
Footnote 39.
Sorry, yes, 39. Yeah. What did I say? Did I say 35? 39. It's footnote 39. On page 51. So it refers to making best use, and it refers to the ANPS, which we've just discussed. And it states that they are the most up-to-date policy on planning for airport development. They continue to have full effect, for example, as a material consideration in decision-taking on applications for planning permission. The government is clear that expansion of any airport must meet its climate change obligations to be able to proceed. So first question on that. In terms of climate change obligations in law, on whom does those climate change obligations rest?
So I think this sentence needs. I mean, to answer the question, I mean, it's not clear. I think they're referring to all relevant climate change obligations in the context of an appeal proposal. But if that was to do with meeting carbon budgets and targets, then that would be national government as Secretary of State. And if it was to do with a particular planning condition or whatever it might be, then it would be the airport or any other entity involved. But I think, but I think it's clear. I think this language just echoes the language that you see in MBU and even the aviation policy framework, which talks about the need for airport expansion to be always subject to meeting the UK's environmental obligations. Including on climate change, and I think that's and as I said earlier, that the ANPS and MBU are mentioned there in the same breath. It's clear that climate change can be a significant consideration under the ANPS from the Supreme. That's been confirmed from the Supreme Court, and as I've explained under MBU, it's clearly a consideration that would be need to take into account at the local planning level as well.
Final area, please, is Corsair and the UK ETS.
Sorry, just when I'm looking at the footnote
Yes.
39, just one point. I think I recall the appellant arguing in opening that the wording of that sentence is such that it should be construed to mean that the climate change obligations in question are those of the airport alone and not relating to aviation emissions related to the airport's operations. Just to confirm that I don't read that sentence in that way, I think it's in context clearly talking generally about the issue of climate change and expansion. The expansion of any airport meeting its obligations is talking about the expansion, and so the climate change obligations generally. Okay, so that's helpful to confirm.
Yes, thank you very much. Sorry, the only reason I was pausing was I remembered earlier in your examination in chief that you referred in your supplementary proof, excuse me, to the DFT's response to North Somerset Council, and you mentioned what you said there. And just to flag that that's the next page over, page 10, paragraph 3.11, which is where you pick up what the DFT has said about making best use, continuing to have full effect. And you set out there what the response says and your views on it.
Yes, that's right. As mentioned earlier, I see it as DFT pointing to the assessment that's been done in NBU as a kind of template, if you like, for how you might look at national emissions at a cumulative level, at the national level. But I don't see it in any way as being an assessment in some way entrenched into policy. And it wouldn't make sense given that DFT themselves are using clearly updated analysis and targets that they're referring to in Jet Zero, and it would be inconsistent with the DFT's own analysis to take such an approach. So I don't follow that. That, as I said earlier, that approach to understanding making best use if it is the appellant's case.
Thank you. Then finally, in your proof of evidence, please, at page 3.16, nope, obviously, paragraph 3.16, on your page 11, you refer to the UK ETS, and in your Appendix 1, you give us the government's guidance on participating in the UK ETS, updated on the 10th of June 2021. So what would you like to say about that? And please draw our attention to any bits in that Appendix 1 that you'd like us to look at.
So yeah, here I'm talking about the new UK emissions trading system and how it applies to aviation as of earlier this year, following Brexit. And what I've emphasised here is the CCC's clear position that emissions trading, cap and trade systems are not on their own a sufficient instrument to achieve compliance and delivery of carbon targets. They say here that it's to deal with myopia. I think they mean short-sighted economic decisions and price uncertainty. And it sort of ties into this problem of lock-in, if you like, where if you build a piece of infrastructure, it's obviously very expensive to undo that investment. And I think from yesterday's discussion, there was discussion of a statement to that effect from Rolls-Royce, where they talked about the costs of delaying the policy and the practical changes that need to be made, and how those become much more expensive and difficult the more you delay them and the more you put them off. But the ETS is on its own. I mean, if it was sufficient, obviously the CCC's analysis for the traded sectors within the traded sector, such as power, aviation, domestic aviation, etc., would be very short. It would say this is our recommendation for the traded sector in terms of ETS allowances. They're problem solved. But it doesn't, obviously, it goes into a lot of detail about other different policy mechanisms you need to achieve with any any measure of reliability the carbon budgets that you're trying to achieve. And just as a sort of supplementary point to that, I think if it was the case that the government thought that the ETS was enough on its own, then it wouldn't have included clear express requirements in the AMPS, for example, to consider the climate change effects of proposals from aviation and flights. If it was the case that simply this was all dealt with by the ETS and there was no issue, it would be very easy for the MPS to have said something to that effect, that carbon emissions should not be given any weight, or and equally MBU could have done the same thing if that had been the case.
Just catching up. Thank you. Can we go, please, to Mr. Osmond Ireland's rebuttal? That's BAL 6/3. To page 11, paragraph 3.4.1. There he picks up what you say in your paragraph 3.16 about the CCC not viewing the ETS as another market mechanism is sufficient. So exactly what you've just been making. And he says here, 3.4.2, the inclusion of international aviation within the sixth carbon budget means that the UK government is not wholly reliant on carbon pricing within the UK ETS and CORSIA to achieve the emission reductions required. What the UK ETS provides is a market mechanism to enable the aviation sector, and indeed any participating sector, to realise the most cost-effective means of reducing emissions. What do you take from that?
Yes, I do slightly struggle to understand the rebuttal point here. If the point is being made that that the ETS and CORSIA are not enough to achieve compliance with carbon budgets, then we're agreed. If the inclusion of international aviation with the sixth carbon budget is somehow suggesting that other policies outside of the ETS are not necessary, then I disagree, but I'm not sure that is what's being said. I find it difficult to understand the rebuttal point in that paragraph, to put it in short.
Well, let's look at what Mr. Melling says on this topic. So if you go to Mr. Melling's proof, please, I'm going to do this electronically, to page 75 of Mr. Melling's proof. To paragraph 4.5.30, even on page, hold on, might not be held on page 75. 4.5.30.
4.5.13?
4.30.
Oh, 30, sorry.
Yeah, yes, it's 79. Yes, page 79. So 4.5.30. So here Mr. Melling is dealing with UK ETS and CORSIA, and he's talking about the inclusion of international aviation in the sixth carbon budget. And what he says is that that does not fundamentally change the position. So he sets out the position above, which is probably why I was starting at page 75, in terms of his proof on policy compliance, and setting out his position that, and this is 4.5.24, at the top of page 78, MBU confirms that changes to emissions arising from the government's support of airports making best use of existing runways is consistent with national carbon commitments, and there's a reference there to MBU. But focusing on what's said about the UK ETS and CORSIA, so further down at paragraph 4.5.30, He says emissions will be subject to UK ETS and CORSIA, and this legal and policy framework at the national level will ensure that the government's climate change obligations are met and the sixth carbon budget secured. I submit that significant weight should be afforded to this framework in determining whether the appeal proposal would prejudice the ability of the UK to meet its climate change obligations. What's your response?
Yes, I think there's a few points to make on that paragraph and that statement. Obviously, the UK ETS and CORSIA relationship is yet to be confirmed, and there are a number of different options being considered by government. But on any view at the moment, CORSIA clearly does not, in any view, guarantee compliance with the sixth carbon budget. It's not based on any kind of absolute reduction in emissions. It is has many problems with the offsetting mechanisms that are associated with it. I've referred to the CCC's clear position on that in my proof. On the issue of emissions trading, cap and trade systems in principle as in of themselves delivering compliance with carbon budgets, again, I would simply point to the CCC's clear advice that that is not a safe way to proceed when you're, I mean, generally, but I would say also in this context of this appeal. And I think also it reminds me of some discussion that was had previously in the week where it was suggested, I think, that because there is a legal obligation on the Secretary of State to achieve the net zero target, that in some way affects the assessment of whether or not this proposal impacts his ability to meet that target. And I disagree fundamentally with that position, if that's correct. Obviously, you can have a legal obligation to achieve something of result, like the net zero target, but something can make something more difficult for you to achieve it. And that's clearly what you look at when you're looking at the impact of a proposal such as this. I think it's referred to explicitly as a core test in the IAMA guidance that Mr. Erzen Ireland refers to, and it's common sense. So just to clarify, I don't agree that the existence of legal obligations in the Secretary of State in any way resolves the climate impact of this proposal. It just explains why it's important that we avoid those kinds of adverse effects where possible. Yeah.
So what weight, therefore, would you afford to the framework, UK ETS and CORSIA, and the government's climate change obligations being secured in that way? What weight would you afford to that in determining whether the appeal proposal would prejudice the ability of the UK to meet its climate change obligations?
I don't know about weight. I think I wouldn't rely on it as resolving the issue of the climate impact of the proposal. And if, as I see it, the best available evidence is the CCC's assessment of what needs to happen in terms of capacity cumulatively, then that is how you go about assessing the climate impact of this proposal, and what weight is given to that impact will depend on the inspector's assessment of the appeal in the round and other factors. But I think, for the purpose of assessing the effect of the proposal on climate change, I would say that the UK ETS and CORSIA are far from resolving and addressing and mitigating that impact.
And throughout your evidence, you've been using the word assess. I mean, plainly, we've got the context of the environmental impact assessment having been carried out, and then we've got the further decision after that of the inspectors having to take a view of the nature of the impact and the weight to be given to that. So can you just separate out in terms of those two things? First, in terms of the obligations to conduct environmental impact assessment, to what extent, if at all, is it relevant that the UK ETS is a legal mechanism for controlling emissions?
I think in this context, I'm viewing the CCC's advice as being the best available evidence on this issue, and by the means of evidence that's reasonable to use when you're assessing effects for the purposes of the EIA regulations. I would view the CCC's advice as clearly the most authoritative in the absence of any coherent government strategy or proposal to address the capacity issue in the context of carbon budgets. UK ETS obviously is a market mechanism that is designed to incentivize the move to a low carbon economy in different sectors and to put a price on carbon. And I'm not criticizing it for what it is, but I think I would agree with some of the comments made by Professor Anderson and I think Mr. Asher when they said that obviously there are certain practical reasons why you can't just rely on many sector-wide mechanism to deliver emissions reductions at the right pace in your particular sector. It's obviously not practical for all of the UK's allowances to be used up by aviation. That's not feasible, and that's why the CCC have not relied on taking that approach.
So that's for EIA purposes, and the analysis might be the same or might be different for the inspectors making their decision, but just as I asked you to differentiate the two, I suppose I should make sure that I give you the opportunity to.
So just to clarify the question, sorry.
Yes, so there's a question about environmental impact assessment and what's the correct approach, and has the assessment of significance been properly undertaken? So that's question one, and you've addressed that. But of course, question two is then, once you've got the environmental impact assessment and the approach that's been taken, and then the inspectors are being asked again to consider UK ETS as the legal mechanism which controls emissions. Is there anything else you want to say about that, or is it just the same answer?
Yeah, I think I'd make the same point that as it's not enough to resolve the issue, I wouldn't see it as diminishing the significance of the impact if one were to be established. And it's obviously, as I said, as a matter of policy, I'm not criticising it, I just don't think that in light of the CCC's clear advice, you can rely on it on its own to achieve the result.
And then you picked up on the fact that there's a lack of clarity at the moment about how the UK ETS will interact with CORSIA. Is there anything else you'd like to say about that?
Really just that point that I think that the stat statement from Mr. Melling's proof, I disagree with on that basis at that level of certainty, where he says that CORSIA, alongside the ETS, will ensure that the government's climate change obligations are met, presumably in terms of international aviation. I disagree with that. There's much uncertainty as to what that will look like. Even I think in a best case scenario, there would be discrepancies probably. But that said, the situation is uncertain, and even if it was as robust as an ETS under the UK system applying to international aviation, the same point would apply about the fact that it doesn't prevent you going off course in terms of the way the actual economy is being invested in and the way that infrastructure is being planned.
Thank you. So just coming back up then to what Mr. Melling says at his paragraph 4.5.24 on page 78. At the top, where he refers to MBU, and paragraph 1.15 of MBU referring to the UK's carbon traded scenario and the carbon capped scenario. And of course his point is that North Somerset councils failed to take proper account of MBU, but of course that's if it holds a criticism of Ban's case as well. So what is your response to that?
Yes, I think it relates to that point earlier about my impression of what the airport's case is on this. It would seem to be that they're saying that MBU has considered the emissions impact of this proposal fully and finally, and said that it's, as a matter of policy, something that should be, I don't know what word to use, disregarded, given little weight, and that I disagree with for the reasons I explained earlier.
Okay. So I have, in fact, done better than I thought I would. And so subject to Mr. Hunter-Jones not having anything else that he wants to say in examination in chief, that is the end of my examination in chief. Thank you very much. Please wait there.
Thank you.
Thank you.
Nothing further?
I don't think so, no.
Okay, right, that's fine. Let's take a break then, and we'll start the cross-examination at 11:15. Thank you. Right, let's resume. Mr. Humphreys, over to you.
Good morning. Mr. Hunter-Jones, as I said with one or two other witnesses, this is just my sort of caution note. Obviously, as you will appreciate, I've asked a lot of questions to a lot of witnesses this week, and I'm going to try not to duplicate. Inevitably, I will a bit, but I'm trying not to. But that doesn't, just because I don't ask about something, I'm sure you'll understand, that doesn't mean I automatically accept it. Just one other preliminary thing. Earlier in the week, Mr. Hone said that there were various legal points on which submissions were going to be made. Are those as expressed in your written evidence?
I would have to clarify with Mr. Hone what that reference is to. I'm not aware of that particular issue.
The only point I was going to make is, and this can be dealt with offline, if there are a lot of legal submissions that are going to be made in closing submissions, it would be quite useful to have some sort of notice of them if they're not in the evidence.
Yeah,
I'll leave that to Mr. Hone. Yeah.
Yeah, it might help, Mr. Hone, if you could give some advice on that.
Yes, so that was in relation to the Paris Agreement, which is not something that's covered in Mr. Hunter-Jones's evidence,
Yep.
and it was just about what the nature of the obligations are. That was in the context of questions to Professor Anderson about that.
Yes, thanks.
Mr. Hunter-Jones, you are, as you tell us, you're a solicitor, and you obviously, everyone makes their declaration, and you're subject to the SRA's Code of Conduct, obviously, and you clearly understand your duty as an independent witness, and also the areas of your expertise as a witness and areas that aren't your expertise. And am I understanding correctly, you're appearing as an expert witness in relation to the law, i.e. as a lawyer. Is that right?
So, as I've described the scope of my evidence, what I'm looking at is, from my experience as a lawyer at Client Earth, working on these issues of carbon lock-in from major infrastructure projects, and my experience of dealing with how these effects are assessed, and my knowledge of the wider climate change legal framework and planning framework, I'm trying to assist the tribunal with my assessment of the approach, the proper approach to take to those issues.
Okay.
I'm not giving a formal legal opinion, if that's a suggestion. I am simply using my legal experience as in order to try and assist the tribunal.
I'm just conscious that at various stages in your evidence you've started expressing opinions about significance of effects and things that I would normally expect to hear from, an expert in the topic rather than a lawyer. Is there a distinction between your area of expertise as a lawyer and the the wider things on which clearly you may have views, but it's perhaps not expert evidence?
I think I would just go back to the way I've described my experience in the proof, which is that I'm experienced in working in the specific area of climate change and planning, and the issues of how impacts are dealt with by developers and how that might fit into the wider policy context of climate change and the climate change legislation, such as the Climate Change Act, is, I think, an area of expertise. But I accept, of course, that it's not a formally recognised area of expertise in the same way that you might be an accredited town planner or you might be an engineer. And so that's, hopefully that's a clarification of what I hope to offer to the panel.
Now, in your evidence in chief, you have in a number of places mischaracterized the airport's case. But in doing so, you've actually confirmed a lot of our case, and I've taken a note of those things, and therefore I don't need to ask you about a lot of the things that I thought I might have to ask you about. So that's good news. Can we just focus on one or two sort of preliminary legal points that I suspect you and I will be able to agree quite quickly? As far as government policy is concerned, that's not a matter for debate at local planning inquiries, the merits of government policy.
The merits, no.
And we also know that you shouldn't try and attack the merits by the back door of attacking weight.
Indeed. I think the distinction I draw there is that obviously talking about the nature of government policy and the weaknesses or flaws may well be relevant to the consideration of issues, but I absolutely agree, of course, that in understanding national policy per se, you would not seek to criticise the merits of it.
And slightly different point, it's sort of similar theme. I thought as I finally got the chance to cross-examine a lawyer, it's not often that happens, I might take the opportunity. We know, don't we, from the decision earlier this year where there was a challenge to the UK ETS system on the basis that the allocations weren't consistent with the Paris Agreement and so on, that was rejected, wasn't it?
I believe you may be referring to the case regarding
The Elliott-Smith case.
Sorry?
The Elliott-Smith case.
Yes, the Elliott-Smith case regarding the particularly energy for waste issue. And yeah, I don't disagree with the fact that that case was dismissed.
And we also know, and as, again, I wouldn't necessarily have asked you this, but from what you were excuse me, saying a few minutes ago about your more general experience, that the NPPF, paragraph 188, be familiar to the inspector, the inspectors should assume, shouldn't they, as a matter of policy, that other regimes to control emissions, for example, will operate effectively?
I think that's right, but with the qualification within their own terms. So the ETS and the other mechanism should be assumed to operate as it says on the tin, if you like, but that's not to say that it should be assumed to solve the problem that it's seeking to contribute to solve, if that makes sense.
Yes. Well, I'm happy that you agree. I'm not going to debate the words with you. I'm happy that you agree that the paragraph 188 policy in the MPPF is obviously material and important, and the inspector should have appropriate regard to that.
Yes, with that statement, I'm agreed.
Again, similar theme, because I found it a little bit more difficult to make progress on some of these issues with non-lawyer witnesses earlier in the week, but I think you and I will be able to agree things. There's no dispute between you and me that the role of the CCC is to give advice. It does not itself create policy.
No, that's agreed.
You do perfectly properly make the point that that the advice of the CCC is relevant, but where, for example, you say that the proposed development does not comply with clear recommendations of an authoritative statutory body, you're not implying that just because the CCC was created by statute, that there is some statutory or other legal requirement for us to comply with its advice to government?
No, that's right. I'm not suggesting that. I'm suggesting that the CCC's advice in this context is the best available evidence for the inspectors to use in this specific context.
And we'll kind of come back to some of those themes. And you have been very clear in your evidence about the recommendations of the CCC in relation to its sixth carbon budget report that government has not adopted. In other words, they have not become policy, and those include the CCC's recommendation that there should be a cap on capacity. That's clearly not government policy, is it? And you made several comments about that, which
yes,
I noted.
so just to agree with that statement, but also to make the qualification I think others have made, including Dr. Hinnells, that's not yet the case. It's quite probable, it seems, on the basis of all the evidence, that that kind of measure may well be needed in the future.
Yes, but that's you, isn't it, with respect, Mr. Hunter-Jones, going slightly beyond the remit of a lawyer to speculate on what government policy might be. You and I think, as lawyers, need to be a little bit more disciplined, don't we? At the moment, there's nothing in government policy to indicate that that particular response to climate change is likely to be adopted as government policy.
So just, I'm not sure what which question I'm referring to, but the point that the development of future policy and the evidence pointing to the fact that the kind of measures, including the Jet Zero consultation, are unlikely on their own terms to eventuate, it is simply a logical conclusion on the basis of the evidence to infer that these may well be required in future. I obviously don't suggest that that should be taken as read as future policy, and lawyer or otherwise, I'm trying to assist the panel in understanding how it's appropriate to consider a proposal's climate effects in the context of wider climate change policy, legislation, and other factors. So just to make clear, I'm not saying that any future capacity constraint policy should be treated as already in place or imminently coming, just that it might, and that in fact that would be the only way, on the basis of the current evidence, that this proposal would be able to fit within that capacity constraint, is if other airports were somehow constrained and Bristol was allowed to grow.
And again, in the similar vein, clearly we can look at the various different pathways that the CCC looked at in its sixth carbon budget report, including but not only the balanced pathway, and indeed the airport's evidence has done that. I mean, it hasn't ignored that. But you and I agreed, and I think it was again clear from your evidence, that whilst of course it's proper to have regard to that, indeed we have had regard to that, it has not become, that pathway has not become government policy and doesn't have that status.
Yes, I agree with the caveat that none of the recommendations have yet been formally responded to in terms of policy. They are being consulted on at the moment, and I think that the nature of the consultation, among other things, means that the CCC's advice on this issue, using the balanced pathway, which it describes as the feasible approach, not just technically but also economically and practically, that's the best available evidence to use in this appeal.
Thank you. That, again, is helpful. And in that regard, you're talking about things like the 23 megaton CO2 in 2050.
Yes, so the aviation pathway, the specific aviation pathway and the balance pathway that the CCC has outlined, I think is clearly a relevant consideration.
Okay, and as you are, of course, aware, our evidence does test the appeal proposal against that, doesn't it?
Yes, but I think in a meaningless way, because it looks at the emissions purely as a percentage proportion of that total number, and doesn't consider the fact that there is simply no more space looking at this issue from a cumulative way. So yes, I agree that obviously witnesses for the airport have referred to the 2050 balance pathway emissions figure for aviation, but all the other recommendations around demand capacity constraint haven't been addressed or engaged with, and the way that the proposed emissions have been contextualized is to put it mildly partial. It's not helpful, and it doesn't help to, when you're weighing up the benefits and disbenefits of a proposal, to understand a proposal's emissions or effects at that scale. It's one piece of information, but it's not very helpful.
I asked you when you said the balance pathway whether this meant the 23 megatons. You said yes, and I said we had looked at that, and you know we're agreed on that. You disagree with what we've done. We can maybe come to that. You then, in section 3 of your evidence, you have a long section on the UK being off track. And again, I was, to be frank, slightly surprised that this was within the expertise of a solicitor. I mean, we can all read the document, but it didn't seem to me, I don't remember at bar school, I don't know about you at law school, ever studying whether or not being on or off track was part of our education. But look, can we just sort of see where we get to? I think you probably do agree with me, but maybe you don't, that the Bayes document is an annual document that plugs in capacity each year and is not only looking at performance of the current carbon budget, which is obviously important, but does make projections out to future carbon budgets. So can we just agree that the purpose of the document is to, in effect, report back to government the effects of different policy initiatives?
Yes, the purpose of the document, as I understand it, is, as the title says for that table, to monitor the performance against carbon budgets, to be used for government planning and record keeping.
And for the 4th and 5th carbon budgets, not only have we not got to the end of those, we haven't even got to the beginning of those periods, have we?
For the 4th and 5th? That's right, yes.
Yeah. So there we're looking at periods that haven't even started yet and for which government is still, as we know, formulating a policy. I don't think you are suggesting, are you, that the policy that either has over recent periods or is currently or is likely over the next 2 or 3 years, you're not able to say as a lawyer that that will not meet the carbon budgets? That's not your evidence.
Just to delineate some of the question there, just to reiterate, I'm not giving a legal opinion here. I'm relying on my experience as a lawyer working in this area and with, I think, helpful experience in the context of placing proposals in the context of the policy framework and the legislation. So I wouldn't want to commit to confirming anything as a lawyer. But I think if the question is is it possible that the fourth and fifth carbon budgets could be met, notwithstanding the policy
Not quite
gap?
the question. I think the question is more, you're not able to say, because you don't know what the policy initiatives are that will develop, over the next few years, for example, the outcome of the Jet Zero consultation, you're not able to tell the inspectors whether the fourth and fifth carbon budgets will or will not be met.
As I was about to explain, that's right. I don't think anyone can predict with any certainty whether it will be met or not, but the clear advice from the Climate Change Committee, the authority on this issue, is that we are currently substantially off track. And that is important context, I would say. I would suggest it's obvious that is important context to consider when you're looking at the cumulative impact of this, the cumulative effects of this proposal. And it plays into the significance. If there was no challenge to meet the fourth and fifth carbon budgets and net zero, then perhaps you could understand, or you go some way to understanding the appellant's position that the emissions aren't significant. But even then, as I've explained in my proof, I don't think that's right, because any emissions that you're increasing is putting a burden on the rest of the economy to decarbonise, and is clearly an adverse effect in itself, and is contributing to further warming. So scientifically, in terms of policy, it is not a helpful approach to simply say these emissions are insignificant and therefore not an adverse effect.
And we know, as you've told us, you've looked at the document. In fact, one of the sectors where carbon emissions are rising rather than falling is not, in fact, transport, it's residences, households.
Could you point me to
Yes, in the document.
the document where you think that's shown?
Well, there's a chart. Figure 2.3, so it's CD 9.87. Sorry. It's CD 9.78. Apologies. And PDF page 16. And that's looking at non-traded emissions. Obviously, aviation, we know, has now just come into traded, but non-traded emissions, and you can see that one of the areas clearly where there is going to need to be policy interventions by government relates to households.
I think I understand the point now. Yeah, I thought you were suggesting that there had been historically reductions in transport emissions in that sector. I see that the projections, when you break them down to non-traded for transport, are decreasing in the future, the residential are increasing. But I don't think it follows from that the transport sector emissions are in line with what needs to happen to meet the various budgets concerned.
I think that's it's a slightly different point. I was just saying, insofar as the inspectors look at the headline figure in the previous table, actually one of the areas where most action is needed is residential households. It's boilers and things.
I think if to the extent that's relevant, I think it outlines the challenges in the rest of the economy. And I think Mr. Asher referred yesterday to the fact that if you take up or you allocate or allow the aviation sector to grow its emissions, that can have adverse effects on households whose cost of heating or whatever it might be affected. So I think all that suggests, I don't see how residential emissions otherwise would be relevant to this appeal, apart from showing how actually there are challenges across the economy.
Yes. And that sort of segues into the next point, which is, in fact, now aviation is going to be within the, obviously it was previously the EU ETS, but now the UK ETS, it will be in a traded sector. And you made, on a number of occasions, points about the CCC criticisms of cap and trade. You didn't take us to anything. I'm not sure those were criticisms specifically of the UK ETS, were they? Wasn't that much more to do with Corsair and those types of schemes?
No. So as I understand the quote from the CCC that we referred to earlier, that's referring to emissions trading per se generally.
Okay. But you then made a point that, well, you know, if this was important, this would have been said in the emissions trading important, this would have been said in the AMPS or MPU. But of course, the importance of what was then the EU ETS is made clear in government policy, isn't it?
Yes, just to clarify, I think the point I was trying to make in that context was that if the ETS was the full solution to the climate impacts of airport expansions, then it would have said so. It would have said you do not need to assess climate impacts because these are all catered for by the ETS. You should apply very little weight to them, notwithstanding the IEA requirements, etc. That would be a way of dealing with it, and that's not what either document does.
And nor is it what Bristol Airport has done either, very clearly. Let's just look briefly at the aviation policy framework, that's CD 6.1. Tell me when you've got it.
Oh, I have it up, thank you.
Turn to PDF page 7. And towards the bottom of the page, it's a sort of bluey-greeny kind of box. Aviation key facts, tackling climate change, talks about gross emissions. But the second bullet point, under the EU emission trading scheme, the EU ETS, obviously replaced now, but the net emissions from flights covered by the EU ETS cannot increase above the levels of the emission cap. And then I'll just take you to a second passage, and then I'll just ask you to comment on it. So have that in mind, and then just turn to page 14 in the PDF. I think it's 14. No, it's not page 14. I'm just going to have to check my paragraph. Just forgive me for a moment. Sorry, it's page 11. Sorry, it's page paragraph 14. So PDF page 11, right at the bottom. And this is obviously talking, it's got before, in the previous paragraph 13, talks about ICAO and the international approach, and it's a topic that we've discussed with others, what government's response will be if Corsair doesn't work. 14, in the absence of an ambitious global agreement to tackle aviation, our strategy is to continue to strongly support action at the European level, obviously now UK. The inclusion of aviation in the EU ETS is a key component of this, and we remain committed to ensuring that it is a success. At a national level, government and industry are taking a number of actions to support the effective working of the then EU ETS and help reduce international emissions. So very clear as a matter of long established and high level policy that although the government, as you've pointed out in relation to CORSIA, there may be some concerns and maybe some criticisms of the CCC, but government's absolutely crystal clear that it sees the ETS mechanism as a key component in dealing with international aviation emissions, a key component.
So there's a few points, I think, to unpack. The first one, that last point about CORSIA being adequate and the suggestion that it's the government's view that's the case. I've set out my proof why that in the March 2020 Decarbonising Transport document, the government said, if there is not significant progress at the international level through ICAO, we will be minded to include international aviation shipping formally within future carbon budgets, which they then did. So I would disagree with the suggestion that the government thinks that progress at the ICAO level is sufficient. Obviously, they've committed to. Obviously, they've committed to.
Mischaracterizing what I've said. I didn't say it was sufficient. What I said was what the government has said here is in the absence of global agreement, in other words, the international thing, in the absence, if that isn't ultimately successful, and there have been criticisms of CORSIA, government's working on that, but if that is not successful, the government's position is absolutely clear, isn't it, that the solution lies with an ETS system.
I don't think that the government has, as I said earlier, it has taken into account the ETS, obviously in framing its policy. But as I characterised it earlier, the government seems to have taken what I describe as a bottom-up approach to managing capacity constraints in the light of that. And it hasn't said in MBU, for example, the ETS is the way we are going to control emissions at the national level. It simply said all relevant considerations need to be taken into account and resolved satisfactorily at the local level. And I think just before we lose the train of thought, you directed me earlier to, I think it was page 7 of the policy document. And under tackling climate change, you referred to the fact that, however, under the EU emissions trading system, the net emissions from flights covered by the EU ETS cannot increase above the level of the emissions cap. Leaving aside the points I made earlier about why the ETS is not sufficient on its own, what I think that's referring to is the way that emissions under the ETS are accounted for under the Climate Change Act in terms of EU ETS emissions, where the net emissions for the purpose of the accounting were based on the UK's share of the wider ETS system. And so as a matter of law, the UK's actual use of those ETS permits didn't actually feed through to compliance with the Act. I hope that makes sense. But that's now no longer the case with the UK system. But I think I just want to clarify that that's not what the government's saying, that somehow relying on the ETS on its own means that emissions from flights are not a problem. And I think that's confirmed if you could look at paragraph 1.24 of the document, which foreshadows the policy that was to come under MBU and the ANPS, which talks about, in terms, proposals for expansion at airports should be judged.
Can I just check where you're reading from?
Page 22, paragraph 124. Proposals for expansion at these airports should be judged on their individual merits, taking careful account of all relevant considerations, particularly economic and environmental impacts. So it's in that context that any references to the ETS are obviously what they are, and the ETS does what it does, but it does not, I don't think on the government's view, resolve the environmental impacts of proposals. And I think that's clear from the context of the policy document.
Yes, but Doesn't this sort of lead into perhaps one of the misunderstandings of our case? The airport has never suggested that the inspectors should not take account of the emissions from the expansion. We've quantified them. They're set out in the environmental statement addendum. They are there for all to see. They're then assessed in terms of their significance, because that's what we have done. But as under one of the tests of significance, we have said these emissions do not have a material impact on the ability of the government to meet its climate change obligations, targets and budgets, because government has the mechanisms available to it by which it can control those national and international aviation. By aviation, I'm talking about aircraft, I'm not talking for the moment about the non-aviation emissions. And now you may disagree with us about whether that is or is not an effective control, but that's not telling the inspectors they can't take it into account. It's telling them they can take it into account, but they must also take into account the control mechanism.
So I think I would agree again that the inspectors obviously should take account of the existence of the ETS, of its nature, what it's intending to do, but I also think they should also take into account the CCC's advice, which is not to place sole reliance on the ETS. And I think, as we just covered, that's also confirmed by the approach the government has taken in setting the airport planning policy framework. So I think there's two different issues. It's not that I'm saying that the ETS shouldn't be taken into account. Obviously it should. It's just not it doesn't solve the problem of Bristol Airport's increased emissions in planning terms. And so that's my point.
So that we are not at cross purposes about what the CCC has or has not said, and I'm sure you've put this in your evidence, and forgive me, my memory is not encyclopedic on these things. Can you just remind me which particular passage you're relying on, not just for cap and trade generally, but for their views on the UK ETS? I'm sure I have seen things. I just want to make sure that I know which bit of advice you're relying on.
So I think the passage I've cited and the most obvious reference I think to date is in the CCC's letter to the government dated of August last year.
I know the one.
And they say advising against placing sole reliance on measures such as the ETS, given that they do not solve the problem of getting to net zero or the sixth carbon budget. And as I said earlier, that's just a logical conclusion as well, given that clearly there are all sorts of policy measures that need to sit alongside an ETS for it to actually, in a complementary way, achieve the outcomes. And it would be very easy otherwise for the CCC to give advice on the traded sector. If that was the case, it would just simply analyse what the traded sector analysis should be as a whole, and then that would be the end of the chapter. And obviously that's not what happens, that's not the debate within government. Dr. Hinnell's yesterday, I think.
Sorry, can I just clarify? Is it the 12th of February 2019 letter?
7th of August 2019.
7th of August, yeah. Sorry, I'm just trying to make sure. I want to make sure I know exactly which one it is.
Is there a CD reference?
CD 934, sorry.
934. 934 is the sixth carbon budget. So that's
there's a CD reference missing in my, sorry, I was looking at the end of the footnote. Let's see if I can find it. Sorry, it's an annex. It's an appendix to my proof.
Okay.
Appendix 2. In summary, our recommendations are the government should not rely on carbon pricing alone. Whilst carbon pricing is essential, it needs to be used as part...
Just slow down for a moment. I've got to Appendix 2. That's obviously a letter of several pages. Which page are you on? They're not numbered. Well, in fact, I suppose the appendix number...
so I was just reading there from page 16 of the appendix number.
Page 16. Yes. So government should not rely on carbon pricing alone. Well, that's not absolutely to do with the cap on allocations. Secondly, we agree the government's preference for a linked UK ETS, EU ETS in the case of EU exit. So, fine. We recommend that the cap of the linked UK ETS be set based on the cost-effective path to new net zero. So which bit says that the government can't rely on an ETS to cap the allowances in the ETS, not the prices?
So, the letter as a whole is talking about the ETS, and it's talking about market mechanisms such as the ETS, and cap and trade schemes requiring a stabilisation mechanism to install such a price profile, for example. And then it goes on to say that it doesn't recommend relying on it.
Sorry to stop you, Mr. Hunter-Jones. We can all, at what is laughingly called our leisure, read the letter. It's just this point that you've made many, many times that the CCC has specifically said the government should not rely on, not just cap and trade generally, but as you've said, should not rely on the UK, as it now is, ETS. And just take me to that bit.
Yeah, I read, you've got the quote in my proof about price myopia and uncertainty, future uncertainty. I just then also took you to the summary recommendation. The government should not rely on carbon pricing alone. Whilst carbon pricing is essential, it needs to be used as part of a suite of policy instruments as confirmed by real-world experience internationally. And the reason I say that applies to the UK ETS in all its forms is because that's what they're talking about in this document. They're not saying the ETS as a trap and trade mechanism is sufficient. They're using carbon pricing mechanisms to refer to the ETS. So I can't point to a statement which explicitly says cap and trade mechanisms should not be used. But from the context of the letter, I think it's quite clear that that's what the CCC are talking about. And as I say, from experience and from the context of their reports, I think it's quite clear that's not their position, that they think that the cap and trade aspect of the ETS delivers the balanced pathway in a credible way.
Okay. Apart from this letter, and we can all read the letter and we can all form our own judgments, I'm not going to bandy words with you on the letter, is there anything else, any other statement that you want to point to that says that the CCC says the government should not rely on the UK ETS? Not in this letter. We'll read the letter and any other document.
To be fair to the witness, it is referred to in the footnote, page 11 at the bottom of his proof, footnote 25, the other document.
That's what I was going to say, is that it's also referred to in the Sixth Carbon Budget Advice.
Okay, but can we look at that as well?
Sorry,
So
can you take us back in stages? Which footnote in your proof?
Footnote 25,
Right.
page 11 of my proof.
So I can see that. Which particular statement? And I'm grateful for my attention. I should have seen that myself. I'm grateful. Again, what passage do you rely on in this document?
So the section I've pointed to is extracted in the footnote, and it says, as set out in our previous advice on the UK ETS, carbon trading and the resulting carbon price should be used as one policy lever within a wider policy package to drive emissions down.
Yes, well, I mean, I don't think anyone's agreeing that there shouldn't be other policy measures as well, but that's not an attack on the UK ETS as being an appropriate measure, is it?
Oh, and if there's been some understanding, again, I'm very keen to point out I'm not attacking or undermining the functioning or the value of the ETS per se and what it's trying to achieve. I'm just pointing out that it's not the full solution to the climate impacts of this proposal and more generally in getting the economy to net zero.
I mean,
and I think just to add to that, if I may, I thought Dr. Hinnell's summed it very well when he described the ETS as too blunt an instrument to rely on. I think that's exactly the point the CCC are getting at, that it's really only one part, and you can't discount the risk of carbon lock-in, of all sorts of things happening if you just relied on the ETS on its own, ensuring that emissions met allowances. That would be an unsafe way to proceed, to put it that way.
Thank you. I mean, the inspectors need to note, don't they, the context for the passage you've taken us to. That's not specific to aviation. That's talking about all the traded carbon sectors. And therefore, yes. What clearly the CCC is telling us about all of those sectors is that the government should look at a balance of things. So, for example, renewable energies, there are all sorts of incentives for renewable energies, strike prices and all of those sorts of things to encourage that type of development. This isn't a specific piece of advice about simply aviation, is it?
No, and I'm not suggesting it is. I'm suggesting that the ETS per se is not to be relied on in achieving the UK's various decarbonisation obligations, and that's clear from the CCC's position. But in the context of aviation, they've also been very clear that the ETS on its own is not enough. And I've obviously explained in my proof of evidence the points they've made around capacity constraints being necessary to stay on course in a credible and feasible way. And so I think I don't follow, if the point is that there's an exception for aviation in the CCC's position, I disagree with that.
Move on slightly. You made the point on a number of occasions that the airport relies on MBU to mean that carbon should be disregarded. I took what I think is quite a good note. I'm never perfect, but I was trying to get it right. I'm not aware that we've ever said, or in particular relied on MBU to say that carbon should be disregarded. Did you want to point me to something, or was that perhaps a misunderstanding?
So I think in that discussion I said, I'm not sure what the word is, disregarded or taken off the table or not significant. I was trying to make the point that I think we established from the airport's witnesses that they're using an interpretation of MBU to diminish the significance of the proposal's climate impacts. And obviously, I don't think that's the correct way of approaching the issue. And whether it's disregarded or made not a significant consideration for the inspectors. I don't think you've said disregarded in terms, but I might be wrong on that.
We know Mr. Island has two tests of significance. One that's particularly relevant in the context of the fourth and fifth carbon budgets is looking at the emissions against the planning assumption, but he also looks at sensitivities in the CCC document, and the other test looks at whether there's a material impact on the government's ability to meet its climate change obligations. In relation to which of those are you alleging that we say that because of MBU, carbon may be disregarded?
Well, I think there's a few problems with, so the test that Mr. Ireland uses, where he says that one of the tests should be whether or not the proposal prevents
Mr.
the UK
James,
government.
sorry to interrupt you. I do apologise. I don't want to debate what you think about the tests.
Oh, okay.
What I asked you was, when you say that we've used MBU to say that the actual emissions are not significant, in relation to which of those two are you alleging that we have said that?
So I think the reliance on MBU comes from the paragraph we referred to earlier, where Mr. Ireland suggests that under the planning framework applying to this appeal, MBU has the effect that carbon emissions should not be should be controlled at the national level and not implicitly not a significant issue for the inspectors.
And
as I understand it.
well, let's go to that paragraph to just make sure what he says. So it's his proof of evidence, paragraph 3.5.10, I think was the one you took us to. Which is on page 35. What it says is it's clear from those paragraphs that development control policies are not in development control policies, so we, in the core strategy and so on, are not intended to apply to carbon emissions from domestic or international aviation. Those are matters for control at a national and indeed international level. Now, draw a distinction perhaps with the non-aviation emissions, which we are through the CCCAP looking to control or influence. But what Mr. Austin Ireland has said there is entirely correct, isn't it? Those are matters. There is no carbon budget for aviation from Bristol Airport. That's a national matter.
Yes, so leaving aside local emissions targets and climate emergency declarations, which may all be relevant and material considerations on their own, but leaving that to one side, what that paragraph says is that development control policies, so as I understand it, the local planning framework that's being applied in this appeal, are not intended to apply to carbon emissions from domestic or international aviation. Now, if the suggestion is the obvious point that the core strategy for North Somerset Council does not regulate emissions as a mechanism like the ETS or like any other government policy, then obviously that's accepted. But I think the implication from that paragraph is that development control policies, for the purposes of deciding appeals under those policies, carbon emissions from domestic or international aviation are, I said, disregarded, off the table, whatever it might be, not really relevant. And so if I've misunderstood that paragraph, then obviously please correct me, but that's how I understood that paragraph.
Okay. Well,
I think, Mr. Humphreys, I've understood what this witness has said about that, and doubtless we'll hear from Mr. Austin Ireland a bit later on as to what he meant by that paragraph. So we can probably move on, I think.
yes, I didn't take long on that paragraph, and I have finished. I've already moved on.
Sorry.
No, not at all. I think think final point, you have drawn the inspector's attention to the CCC's advice on balanced pathway, and we touched before on the 23 megatons CO2 in 2050. We should note, shouldn't we, that the CCC's balanced pathway itself assumed a substantial growth in aviation.
As I understand it, it assumed a 25% growth in aviation demand on pre-pandemic levels. Yes.
And can we just look at that for a moment? And you'll have to forgive me. Just take me a moment to get the page for you. I think, if you forgive me for a moment, if I look at another note, I can probably have get the reference. The increase, the 25% in the CCC's document, I can't take to the numbers, but I know what the numbers are. I just can't find the page reference because I wasn't expecting to deal with this point. The increase that they look at, the 25%, is from the 2018 actual level, so pre-pandemic. The increase is about 73 million passengers per annum.
I need to double check, but I'll assume that's right.
I'm pretty confident
For the
I've
purposes
remembered
of this
that
discussion,
number.
yeah.
I know the number, I think the 2018 number was 292 million, and I think the CCC's number is 365 million. Can you just check if that's 25%?
That's right, 365, yeah.
Yes, and that, from recollection, and I'm so sorry I can't remember the page number, is 73 million. So even looked at against the CCC's balanced pathway and the additional throughput it is assuming, so I'm not going to talk about capacity, but the additional throughput it's assuming, even on that basis, the appeal proposal is a very small proportion of what the CCC itself says is necessary to get to net zero.
So, I mean, obviously we've dealt with this point a few times, but just to perhaps try and give it some practical analogy, I mean, it's a bit like Bristol Airport turning up at an airport for a flight that's full and saying, well, it's only me, and it's only my one bag, I'm only one passenger, can't you let me on? Well, no, because the flight's full. And for you to get onto that flight, you need someone to get off.
But Mr. Hunter,
and so
the flight
this is the
isn't
problem.
full. There's an extra 73 million passengers worth of throughput. Why shouldn't Bristol Airport, you weren't here in the earlier topics, but looking at its socio-economic benefits, why shouldn't Bristol Airport have its share of that overall increase that the CCC itself says meets net zero? Why shouldn't we have some?
Well, I think we're getting into the overall merits of the balance of the appeal, which I think is rightly for the inspectors to decide, weighing up the socio-economics with the climate impacts. My point is that on the basis of the current position, the CCC's advice is very clear. There should be no net expansion, given that the increase they envisage is within that current total capacity. And so it's not safe to continue expanding airports until the industry has significantly outperformed the already quite ambitious assumptions that are included in the balanced pathway. And so that's context in understanding the climate impacts of this proposal. I think that's the most relevant evidence and most best available evidence. But I don't prejudge the inspector's view on the overall merits of the appeal.
No, the CCC didn't say no expansion in terms of throughput, as we just said. It's a 73 million passenger per annum increase in throughput. What they said was no increase in capacity, but that assumes that the capacity is in the right place to meet demand. It's what if the capacity is at Aberdeen Airport and the demand happens to be in North Somerset or Gloucestershire? Surely it's perfectly proper, isn't it, for the inspectors to take into account where the demand is?
Yes, and again, perhaps I'm going to just try and explain how I understand the CCC's advice on this. I think what they're saying is that if you allowed, irrespective of where the growth might end up going, if you allow capacity to increase, the risk is that all of the capacity is used. So there may be evidence about demand being in a particular place and forecast to be a particular direction in the future, but the risk clearly is that demand fills all the capacity that's currently consented, and then that would just about fit within the balanced pathway. But if you then went above that and allowed new capacity, you would then risk putting the aviation off course from what is a credible, feasible pathway to net zero and the carbon budgets along the way. So that's how I think the CCC's advice should be understood. It's clearly it's possible in the same way that the Mr. Ursula Ireland's test of does this proposal prevent the UK government meeting its climate change obligations, but clearly that it's theoretically possible that it could go ahead and it would be met. But the question is it likely, is it a safe way to assess the proposal? And that's where I disagree.
As you neatly put it, but there are some topics where we clearly disagree. But Mr. Hunter-Jones, thank you very much.
Thank you.
Okay, thanks very much. Is there any re-examination?
So maybe. So thank you. Just two questions. So the first question, hello again, Mr. Hunter-Jones. The first question that I have is about when you were asked about paragraph 188 of the NPPF. Do you remember that? And
yes, in the context of...
So it was in the context of the UK ETS.
Yes, that's right, yes.
And you were reminded of paragraph 188 of the NPPF, which, as you will know, because it's embossed in your mind and everybody's mind in this planning inquiry, the whole of the NPPF, is the focus of planning policies and decisions should be on whether proposed development is an acceptable use of land, rather than the control of processes or emissions, where these are subject to separate pollution control regimes. Planning decisions should assume that these regimes will operate effectively. So, do you understand from that the UK ETS is covered by separate pollution control regimes?
I think I understand the question to be, does the ETS fall within the pollution regimes referred to in the paragraph?
Correct. Sorry, did I put it poorly?
Yes, I think that would follow. Yes, I think if we're looking at extraneous mechanisms outside the planning system, then yeah.
And then following on from that, the paragraph talks about when an assumption should be made that those regimes will work effectively. Are you aware of, or can you help the inquiry about what the legal position is or the policy position is on when that assumption should not be made? And if the answer is no, that's fine. because I can obviously make some submissions on that. But I thought I'd give you the opportunity if you want to.
So I'm just going to pull up the paragraph just so I'm clear on the question.
Yeah, sorry, it's page 54 of the 2021 NPPF.
Yeah. Yeah, so I've got the paragraph up, yeah.
Yes, so sorry. I should have waited for you to get the paragraph. So you'll see there's the first sentence which refers to separate pollution control regimes, and then there's the second. Planning decisions should assume that these regimes will operate effectively. And then the third sentence deals with where planning decisions have an impact on pollution control. So looking at that middle sentence, can you assist in relation to the position or in law or in policy as to when that assumption should not be made?
So I think what would be, in this context, the position would be if there was an issue about whether or not Bristol Airport or operators using Bristol Airport were complying with their obligations under the ETS, and that was an issue. That paragraph suggests that you should assume that those obligations will be complied with, if I've understood the question correctly.
Yes, thank you. That's helpful, and then I can make some further submissions flowing from that. Then the second question is just that you were asked about carbon budget 4 and carbon budget 5, and it was put to you that they haven't started yet. CB4 is 2023 to 2027, and CB5 is 2028 to 2032. And that was in the context of the discussion about whether it's possible to understand whether those carbon budgets will be met or not. And you answered in relation to why the CCC says that the carbon budgets, that we're not on track to meet the carbon budgets. But I wanted to give you an opportunity to comment on exactly that point, that we're not at 2023 to 2027 yet, or indeed at 2028 to 2032, but we are at 2021. And what do we take, if anything, from how close we are to those carbon budget periods?
So I think, in my proof, I've pointed to the fact that the CCC have said because of the new net zero target and the much more stringent pathway we need to follow to achieve that versus the previous 80% target, that obviously has a direct effect on the sixth carbon budget, which has just been set, and informs that. But it also has an indirect effect, if you like, on compliance with the fifth carbon budget, where it recommends that the government should seek to significantly outperform the fifth carbon budget to stay on track in a credible way to meet the sixth and further and the further budgets and the 2050 target. And in that context, they emphasise that the 2020s are the crucial decade for effective action to get on course. And I think that perhaps is relevant to the point I was making earlier about the timescales here and the realistic nature of policy overnight or within a matter of months, turning a ship like the UK economy round in any significant way on carbon, when experience has proved that it takes a lot longer than that for policies to actually have an effect in the economy. And that does obviously is echoed in the CCC's position that there's real urgency to start addressing what they call the substantial policy gap.
So thank you very much. Those are my questions.
Okay, that's fine. Thank you both very much. Let's take a break now, slightly earlier than normal, till 1:30, and then we will switch over to PCAA and Mr. Johnson. Okay, 1:30 then. Thank you.